further ado, I'm going to go ahead and call to the podium Mr. Joseph Ariola to deliver some welcoming remarks and to introduce the Attorney General of Guam. Thank you.
Thank you all for coming. Actually, I'm overwhelmed. Thank you. Before we begin, I'd like to give you some safety briefing in the event of an emergency. So we need to evacuate the building. There are 4 exits here. One way you came in, one way to my right, one right to the kitchen. That is not an exit. Can't hear you. Get closer to the mic. How's that? There you go. Very good. So, everybody familiar with the exits? Okay. I'd like to thank every one of you for coming. I'd like to thank Mayor Marco for his kindness and generosity on having us use his community setting. Other than that, I hope it's not going to take us all day, but I'm sure we'll get through it. And I'd like to introduce the Attorney General of Guam, who's been very instrumental in making this happen, and a wonderful crew they were setting up yesterday, and it was like clockwork. I was really impressed. So, again, Attorney General of Guam, Mr. Douglas Moore.
My name is Doug Moylan. I'm the guy that hopefully most of you guys voted for me into office. You know, good or bad, I am the person that has to make some important decisions for our community. First, I'd like to obviously thank Mayor Paco, Joe Ariola for putting this gathering together. It was because of them that Joe Ariola asked me to be here today to try to explain your elected Attorney General's, your Chief Prosecutor's position dealing with the laws that have been passed. I'd also like to recognize and thank Senator William Parkinson and Vice Speaker Tony Atta for being here today. Senator Parkinson has been very instrumental in getting the Castle Doctrine into our community, and then a recent amendment as well. I'd also like to thank the mayor and his staff for hosting us. This is a very nice community center. And as I told the mayor when I came in, whenever I go through MTM, not only do I hear rumors about how well the mayor ensures law and order in his village, but just driving in here, I think you guys see the nice roads, the buildings that are all painted up. I come from Dededo, so it's a big village, a lot of work, hard to keep the village in shape. But MTM definitely, it's a very nice place to be. It's an honor to be here today. It really is an honor because I think I'm before a crowd of law-abiding people. I'm before a crowd of people that want to follow the law and are trying to find out how to follow the law, especially as it relates to the most important thing for all of us, which is our safety of ourselves and our families. As we go on with this discussion, and it'll be about 40 minutes, and then this is all about you today, so we have at least an hour set up so that you can ask questions of myself and our prosecutors that are here today. I have, I see Senator Tiller. Senator, can you come on board? So also welcome Senator Tiller, who's all here, who happens to be my oversight chair. So, can you clap for her? She actually is a very good senator and has been very protective of my office, your office, the Attorney General, which is a law firm, for the past 2 years that I've been there. She's been very law and order, ensuring that we get the resources and the tools in order for us to protect you in our community. I also want to thank our team here that are spending their Saturday with me. To my right, I have our Deputy Chief Prosecutor, Grant Olan. To his right, we have Chris Reyes. Chris Reyes is one of our new prosecutors. When I came into office, unlike 20 years ago when I was honored to be the first elected Attorney General, there are not enough attorneys on Guam. Some of you may say that's a good thing. Others might say that it's a bad thing, especially when you think that it's these people that are the ones that are keeping us safe, because they're the prosecutors. Nothing gets filed in court without the Attorney General and our prosecutors. We are the beginning of the criminal justice system, which has a case number before the judges. The judges are not the ones that start the cases. They're the ones that administer our criminal justice system. It's the Attorney General's office that has to look at the police reports, work with the Guam Police Department, Customs, all the law enforcement agencies in order to see whether or not our laws were broken. Also to my left, I have our acting deputy of the Government Corruption Division. It's also a prosecutorial type of division. So I thank my team for spending their time here to be with us. They're here as a resource for all of you so that we can best answer your questions. Okay, preparing for this event today, there was 3 words, a phrase that I thought would be the best way to open up this discussion that we're having here today. Life is precious. I think that whether you're an advocate of self-defense or whether you're on the side of people that feel that people should not have guns, that group, I think everybody will agree that life is precious. And I think that when you always step back a moment and think about the Castle Doctrine, the right of self-defense, whatever is in the statutes, your firearms, your weapons, your spears, your crossbows, anything that one would think to defend themselves, when you treat life as being precious, when you respect the law, like obviously all of you do today, you understand how far to go when needing to protect yourself or to protect a loved one. And I think even in the religion, the protection of others is always considered a higher form of salvation, or whatever you want to call it. Understand that when I was invited to this, I first of all thought these are our Second Amendment gun enthusiasts. These are people that believe in the right to protect yourself. But this is not the core focus of what we're here today, what our statutes are talking about. The law is not drafted around firearms. The law is drafted around protecting yourself, protecting others. The ability to use whatever you have, and that's even your hands. So as brutal as killing somebody by strangling them or using your hands to kill somebody, to protect. So we're talking in this discussion today, we're talking about the firearm, the knife, crossbow, machete, spear, even chemicals. Throwing acid on somebody can cause death as well. My point is that the law and how we're going to talk about it today is dealing with this idea of self-defense and defense of others. A note that I wrote down as well is, when you talk about hurting somebody, the idea of using force to hurt somebody is usually the other side of the question of what you're doing in order to protect somebody. When you fire your firearm, you don't fire your firearm to kill a person because that is who you are, that I want to kill somebody. We should all be thinking as a community that you use that force in order to protect something more than what you're aiming or trying to hurt or kill. To protect yourself, self-defense, to protect your family, your children, your relatives, or even the common person off the street. One of the cases that I took to trial many years ago as a defense attorney was protecting a FSM, non-U.S. citizen, that was accused of a crime, and I believe it was he killed somebody. But I won the case by appealing to you who sit in our juries because he was protecting his friend against other drunk Micronesians that had attacked them. And the prosecutor, the Attorney General at the time, felt that because he had killed somebody, that he should be charged with a crime. I will assure you here today that I am not that type of person. I'm not the type of person that just because you kill somebody, that you're automatically going to be charged with a crime. That is not the person that I was raised to be. if anybody of you knew F.L. Moylan, which was my grandfather that came to Guam, he was not only a businessman, suffered through the Great Depression and became the American dream coming to Hawaii to Guam, but was also a nighttime reserve police officer for decades. He taught us in our family the respect that you must have for life and the respect that you must have for one another and the firearm. He was the manufacturer's representative for many of the name brand gun names out there, Colt, Glock, and many of the other firearms that he brought into Guam. And I would ask him, why don't you have a full room of all these firearms? You know, because a lot of people wanted firearms. He was one of the first, not one of the few, firearms dealers at the time, ATF licensed. And he never really talked about it much, but my impression was that he knew exactly what those firearms could do. In the hands of a good person, like I presume all of you are, it could protect your life and it could protect someone else's life, your family's life. In the wrong hands, it could kill you. And that's the type of things that we're talking about today, if we talk about the firearm. Also, this idea of firearms, we need to step back a moment. Again, I use a lot of my history with my grandfather. He brought in firearms also for sportsmanship. He had a sporting, his business had his sports section. We all know that firearms aren't just for self-protection. They're used for hunting, recreation, sporting, and then collecting, for those of us who like to collect. So it's with that type of background that I'd like to go forward. Now, I don't care what anyone says and how any judge or attorney general or prosecutor analyzes the cases. The beauty of the United States is that ultimately each one of you will decide whether or not the facts warrant a person losing their liberty for having used your firearm, your weapon, to protect yourself. At the end of the day, it's going to be all of you sitting on a jury that are going to decide whether or not myself and our prosecutors, if we chose to prosecute somebody for a situation where they were defending themselves or their family, has a case. Okay? So, as difficult as it is to be a lawyer, to understand our statutes, and it's not an easy statute. The Castle Doctrine is not easy to understand. Also, before that, the idea of the self-defense is not an easy concept to understand either. But at the end of the day, with all of you, I don't care how much education you have, when you're given that story in court and you feel that it was wrong to have charged this person, and you're asked by the judge to go back into that jury room and to make the decision, the infinite wisdom of everybody that I'm addressing today, and to this day, it still amazes me. You put 6 people together, you put 12 people together, and you get justice. There are more cases in my 33 years as being an attorney that I've seen the jury go back to that jury room and deliberate, that the wisdom that you all have on what was fair, what wasn't fair, and especially that ability, and judges don't like hearing this and lawyers kind of cringe at it, jury nullification. That's when you may be dead to rights with every element of the case that you committed this crime or this person committed this crime, but the ability for 6 people all together, if it's a misdemeanor, or in most cases when it's dealing with a murder, the 12 people all getting together and all coming to a unanimous decision that I don't care what the facts were, this person was put in a situation that required us to let him go. To not take that person's liberty because we didn't think that this was a fair case brought against him. And even before the gathering today, in our national dissertation, as recently as the Daniel Penny case in New York City, where you had the former military Marine that put the person in the chokehold and the person eventually died, listening to all that occurred in that case and how the jury couldn't come to a decision on the main charge of believe it was manslaughter, but came to an acquittal on the second charge, and he was acquitted and was not convicted. The George Zimmerman, Trevin, I think it was Martin case, where the neighborhood patrol person had felt that his life was in danger and shot Trevin Martin. I believe he was either a young adult or a teenager. And then the Kyle Rittenhouse case during COVID, where an upstanding individual made the decision whether that was good or not to take his AR-15 or his rifle into a riot situation, and then was accosted and had to go to trial. Ladies and gentlemen, when I looked at those cases, and especially what they did to that Daniel Penny in New York, I put myself in the position of a juror, like I had just mentioned. You had a very enthusiastic district attorney of New York that felt that, and that was a woke, for lack of a better word, soft on crime woke type of DA, that felt that this person should not have the benefit of not getting charged, and they should get charged. Well, as an attorney general, I don't, and then given my age and how many years as I've been, I don't believe in that. I don't believe in charging people when in fact they should not be charged, and that the attorney general should exercise the prosecutorial discretion and choose not to put people through the hell that people get put through. Daniel Penny went through hell. Anyone that's ever been charged with a crime is going through a certain amount of hell, whether it's self-imposed or it's just because they're a victim of the facts and circumstances. George Zimmerman, I think even after he had to go into some undisclosed location because of a group of the community that felt that he had murdered that teenager. Kyle Rittenhouse, the same thing. So, I also want to recognize our Chief of Police, Steve Ignacio. Him and myself, since I took office 2 years ago, the Chief of Police, in my opinion, reflects the same law and order and reasonable approach towards applying law enforcement on Guam. I keep on complimenting him, having been in our community so long. I remember a time when we had a lot of unsolved crimes. And when I was first elected AG, we had to deal with a lot of the unsolved crimes. And that was about 20 years ago. Since I've taken office, and even before that, I've noticed that under Chief Ignacio's leadership, his team quickly comes to the conclusion after their investigation of who is involved and who should be charged. Whether or not we're able to figure it out from that point, the fact that they're actually finding people and tracking them down, I think our police force, and especially with them too, not having enough post-certified law enforcement individuals, and I appeal to our senators here, please relook at that post-certification, because it's causing, we in law enforcement, for my investigators who are also here, to be considered peace officers, as well as we are considered peace officers, prosecutors, we're not getting enough law enforcers on Guam, and we need to look at it. It's not enough police officers, there's not enough AG investigators, there's not enough prison guards up there. So, as a community, we need to be graduating and certifying more peace officers so that we can be safer as a community. The role of the Attorney General is that it is a democratically elected position. 4 years, Guam first started it, passed in 1998 by Congress, and it became elected in the election of 2002. We've had 6 Attorney Generals to date. I am fortunate enough to be the 6th elected Attorney General, as well as having been honored by all of you as being the first elected Attorney General. The toughest AG on crime was crafted after literally 20 years of being in this position, and as the late great Charles Troutman once said, that after I lost the first election, it would take several elected Attorney Generals for the Guam community to finally understand what it means to have an Attorney General. The Attorney General is not like a senator, is not like a governor, is not like a mayor. The Attorney General does something to people that you're going to have a group that agrees with what the Attorney General does, you're going to have a group that disagrees, because when we go into court, there's a winner and there's a loser when you're asked to bring it to judgment. When you're asked to ask you as jurors who wins and who loses. And obviously the loser, which could be the defendant, they're not going to be very happy with the prosecutors, nor will their families be very happy. That's one of the problems that all attorney generals on Guam face. And I've taken the position that we need to have a tough attorney general. We need to have an attorney general that enforces the law. And I have to be humbled by the senators here in the legislature. When they pass a law, they mean it. And when they say that this is the law of Guam, we as attorney generals, and we are civil and criminal, by the way. Unlike in the states, some of you understand, they have the district attorney, which handles a lot of the criminal stuff, and then they have an attorney general that handles mainly the civil stuff for the most part. Guam, in a small community, we have an attorney general's office that's criminal and civil. So it's with that type of approach that I run my office of about 200 attorneys, investigators, paralegals, and support staff. We are the toughest law enforcers, but at the same time, like I said, I also have to try to be reasonable and understand that you are the client. The people of Guam, and as we get into the Castle Doctrine, the plaintiff is the people of Guam. In every criminal case that's filed, it's the people of Guam that are the plaintiff, and their attorney is the elected attorney general, who you people decide will be there for 4 years. Many of our cases on Guam are fact specific. That is a key factor that all your questions are going to be gravitating towards as my prosecution team and I try to field your questions. We cannot give you a 100% answer for the most part because a lot of these things turn on facts and what we can prove in court based upon the evidence, the testimony, and all the things that happen, whether it's the police officers, their forensic lab, and then ultimately the jury to decide. Vigilante justice versus a law-abiding community. I got to tell you that I'm not I can't say I'm an advocate of vigilante justice, but I'm not an advocate of waiting for the police if a situation arises. The billboards that you guys have been seeing kind of reflect that on the idea that the one to my left, protect yourself. That is one of those situations where the Attorney General is making a statement to you that if you're faced with an individual that threatens your life, your family's life, and the little kid's life, you have an Attorney General in our office that is willing to look at the facts and decide not to charge, even if it ends up in the person's death. The Kinata case, I took over the office. Remember Officer Kinata that went to that gas station and that non-U.S. citizen was shooting slugs, rebar slugs, if anybody of you have dealt with rebars. It's like a shotgun slug. He was using his slingshot and shooting at people at the gas station, so the GPD officers were called over in order to address the people that were being victimized by that individual. The incident ended with the police officer shooting the individual, and then he was prosecuted by the last AG's office. This is what we talk about when the Attorney General has prosecutorial discretion. It's completely upheld by the Constitution and the Supreme Court of the United States. The function of the executive branch, unlike the judicial branch, is to decide whether or not a case should be prosecuted. Again, you may have a person dead to rights that they murdered that individual in the last AG's view. That officer murdered that non-U.S. citizen that was shooting those rebar slugs at the people at that gas station. When I came in and I saw that as part of the debate on becoming the Attorney General, I wasn't so sure that he had acted in a reckless disregard for human life. We reviewed it, and what was the first thing I did when I came in? I called up the defense attorney, and I said, give me your best case of why you think your client shouldn't be continue to be charged. A police officer shouldn't continue to be a criminal defendant to be put in jail for what he did. And the defense attorney said, talk to the general manager at the gas station and hear what she had to say. So we contacted her, and I asked her the question. We asked her the question, do you believe that the officer was justified in shooting the individual? And she said, yes, because the person that was murdered, the non-U.S. citizen that was killed, would have killed us had the officer not shot him. In that case, he had actually got into a car and was using his car and spinning it and hit the officer on I think it was the leg. Didn't disable him, but the officer pulled his firearm out and started shooting into the car and killed the individual. So that's the prosecutorial discretion that I'm talking about here. That is why you need to elect an attorney general that understands the law and has the common sense. And again, those words, reasonableness, common sense, and jury all go together. You don't have to have a law degree, you don't even have to have an education to sit on a jury in our country. And that is the priceless beauty of the jury system. The common person gets to decide whether people should have their liberty taken away. Rule of law, the presumption of innocence. And this is when I go back to that vigilante justice. Be careful whenever you take the law into your own hands, even though I get it. Sometimes you need to do that. But the lynch mob is never the solution to problems, because we all must understand that we're all innocent until proven guilty. We're in this society of following the rule of law, and that what if you were on the other end of the lynch mob? That because of somebody's misunderstanding of the facts, which happened, by the way, I think there was a case with the father and the uncle. There was a juvenile walking in front of the house. Within the past 2 years, they grabbed the guy and they beat the shit out of him. Excuse the language. Then they find out that he had nothing to do with the robberies that were going on down the street. Our office decided that we had to prosecute that, because what do you do with the crime victim? The kid that was yanked off the street and beat up by, I think it was either brothers or a father and his brother or his son. You know, that's why, ladies and gentlemen, as I speak to all of you, I ask you to balance. You need to balance this idea of taking the law into your own hands, and then understanding, is it better to wait for the police to come in? Is it better to wait before you pull the trigger? And then other things. The history of the Second Amendment. The Second Amendment, as hopefully everybody understands, was never about home defense. The Second Amendment was about overthrowing your government. It's about England. That's why I always laugh when you ask the English what do they think about the Second Amendment. Oh, nobody has guns in England. I'm sure you don't. The United States passed the Constitution, put the Second Amendment in the Constitution, which is above every statute, in order to allow us to overthrow the government in the right circumstances. That is the essence, the militia, the right to bear your arms and to overthrow a government that is no longer serving you. So as these Supreme Court cases go through the court, they always temper what was the founder's original reason for it. And then, of course, the whole idea of the tradition of letting people have firearms goes back to this idea that we have a right to protect ourselves in self-defense. The Heller case, and I kind of wrote that down, and as recently as I believe 2008, the U.S. Supreme Court, because I was always wondering, is the right to self-defense a fundamental right, like the right to raise your children? It's a fundamental right. You can't get CPS coming in and saying, hey, stop hitting your kids. That's not, you're violating people's fundamental right to raise their children the way you want. You can't beat the hell out of your kids, but I mean, there's a balance. That is a fundamental right to raise your children. The U.S. Supreme Court has identified the Second Amendment, the right to bear arms, as an inherent and let's just use the language here. A natural inherent right. The right for you to have a firearm is a natural and inherent right. That's a very interesting set of words that they use, as opposed to just saying it's a fundamental right. It's along those lines that they temper the self-defense argument. Okay, before the Castle Doctrine, self-defense, you had the right to self-defense and to the defense of others, and that is a fundamental, inherent right that traverses even the American culture. It goes back to even religion. The idea that you have a right to kill another person in order to protect yourself, but that's where the nuance is. In common law, in common law is a law before we had all laws. It's like comes from England. You know, a lot of our laws are derivations of what we inherited from England as a people, as a country. In common law, when you are faced with a threat, you have the right to defend yourself with an equal amount of force or less. A person comes at you with no weapons and is trying to just hit you. You can't pull out your firearm and take him down. You would be rightfully convicted of murder if you did that. In common law. Since the common law time, they felt that there's situations where we need to increase the rights of certain individuals. In that situation I was using, a person comes at you with a knife, okay? In common law, a person comes at you with a knife. You have the right to pull your firearm out, hopefully warn them, and hopefully shoot them in the arm or the leg. And that's where I wanted to talk a little bit about all of you who are marksmen out there that have these nice firearms, knows what caliber to use for what situation, things like that. A firearm is a tool. At the end of the day, your firearm is a tool. It's a tool that you use in order to protect yourself. Person comes at you, deadly weapon, deadly response. That was the type of laws that we have, except that you have now the Castle Doctrine. The Castle Doctrine is in 3 categories: residence, business, and vehicle, occupied vehicle. That is where you get this special exception to escalate a non-violent situation, potentially a non-violent situation that you're faced with, to a deadly situation where you get to use deadly force. Our statute isn't as easy as what I just said, but that's kind of like where our starting point is for a Castle Doctrine analysis. This idea that I don't want to, the people of Guam, the senators, do not want to ask those little questions. Did they only have no weapon when they came into your house at 2 o'clock in the morning? When you're still groggy and you're trying to fumble around for some weapon to defend your family, yourself, and you're going to be potentially losing that house because you're going to have to hire a lawyer that's going to have to defend you in a case that the Attorney General's office brings. That is what was at stake when the Castle Doctrine type of laws were being passed in Guam. Took the Castle Doctrine that was being thrown around in the States in order to pass it. The idea is that your home is your castle. It's very Texas, by the way. The I believe Texas was one of the first states that started this whole cowboy thing where, respect me or else. So, in those 3 situations, in your home, and that's your home, it can't be like a ranch that nobody goes to, where you put a, what do you call it, the trap, the door trap, where you open the trap and then the thing explodes on you, kills the people. Very Texas again, where they try to protect their barn by putting a shotgun on the other side of the door. So yeah, Guam, no, don't get me is good or not, just quote me on this. You can't do those type of traps on Guam. So it's this idea, the facts would come down to the AG's office, person shot an individual coming into the house, and worst case scenario is it's in the middle of the night, where it's dark and it's hard to see who's coming at you. So, the statute, let's start getting into the statute a bit. The presumption of deadly force is allowed when it's in your house, your occupied car, or your business. And I think they put business in there because a lot of us on Guam, the business people live in the business. They have the business upstairs, the residence upstairs, or they have in the back room. So the senators, in their infinite wisdom, decided to include businesses as well as where you have a Castle Doctrine type of protection. It is presumed that it's deadly force, even if the person doesn't have any weapons on them. When, in one reading of it, this is the first part, that they're lawfully there and they're using force. And that's the Castle Doctrine. You guys want to go down a little bit to show that. We're looking at section 7.112, home protection, use of deadly force, presumption of fear, death. Now, in 2016, the Guam Supreme Court, in the John case, basically, and by the way, the 2 cases that we kind of looked at before we came over here was the John case and the Mendiola case. The John case went up to the Guam Supreme Court where an individual was being charged, and the homeowner was killed, by the way, in the John case. So they charged, the assailant came in and said that they were being charged with having murdered the individual there. The AG's office attempted to use the Castle Doctrine. The Supreme Court of Guam says, no, you can't be saying that this, I believe that was Rages that died there, that person was defending his castle. he had the right to kill the person, but he was killed, he was actually the person that was killed. The Supreme Court of Guam said it was on the curtilage. Now, this is where we have to be very careful in having discussions with my prosecutors. This is very dangerous, and although they put me in the newspaper saying that I fully supported the expansion of your home to the curtilage, that was a very dangerous thing. And this is with respect to Senator Parkinson. I know why he did it. He did it in order to provide more protection for all of us that are homeowners, okay? That is a very dangerous statement. And this is why I ask all of you and people that may be doing this, always approach these fact patterns with life is precious. Life is precious. Those of us that have homes, realize your home is your house, got doors, windows, that is your structure. The curtilage is that area around your house. That's that area where some of us have gates up, some of us put coconuts to show where the property lines are, some of us put even brushes up around it. Guam law right now allows a homeowner to, or by the way, it's not even a homeowner. You don't have to own the house that you're in, by the way, in order to exercise the Castle Doctrine. It could be your aunt, your relative, or a friend that's living with you. They also have the right of the Castle Doctrine protection. But in the curtilage situation, and let me just jump to the point here. I live in a village, lived in subdivisions all my life. That kid, or us, in the summer, when that ball goes over somebody's gate, we were jumping the gates, looking for the dogs, grabbing our balls, and getting out of there in the summer. Under the Castle Doctrine, there's a possibility that if the notices are up, like you gotta put up a no trespassing sign on the property, and it doesn't even have to have a gate, that you, as the home occupant, has a right to say, I shot the person because he was in my curtilage. That's how dangerous the statute is right now, that they could try to get protection for that. And any of you that have children would be devastated if your neighbor, thinking that your kid at night was just playing basketball or something, soccer, and his ball went into the yard, and they jumped the gate, and then somebody put the gun out the window and shot him because he was in the curtilage of the yard. That's the danger, and that's why all of you that have firearms, in the handouts that we've had, anyone that has a firearm knows that the first thing that you must understand is safety for yourself and safety for that firearm. You do not shoot at a target that you don't know what you're shooting at. That is a rule of basic firearms training. Just because you see the silhouette of a person in that curtilage, it could be a teenage kid that lost his ball in there, or his cat jumped into the yard, or something like that. That's why this is very serious stuff that we're talking about here. But if you knew that, if you knew not to shoot first and ask questions later, you probably wouldn't be in a situation where somebody in the curtilage was shot and killed because of a fear. I think most people will agree that fear normally starts when the person is coming at the house, trying to get through the door sort of thing, or the window for that matter. So our statute has a lot of exceptions. If ever you guys see anyone in a uniform, do not take a shot. Because when I was reading through all these exceptions here, there's no protection in our good senators. When you're wearing a badge, usually the homeowner, and I'll use the word homeowner for lack of a better word, but as I said, as long as you're in that house rightfully, you have the right of protection, the Castle Doctrine. If that guy comes in with a badge, even if he doesn't say, police officers, I'm here, and you shoot that person, you're probably going to be able to be prosecuted and not have the Castle Doctrine to protect you. So again, you need to know what you're shooting at. You need to identify what you're shooting at. You need to try to use non-lethal force. And I think people that are good at shooting can hit them in the leg, can hit them in the arm, cannot use the body mass. Like our little cute target over here. Try not to hit him in the head. Try not to hit him where the vital organs are. The legs are usually a good point. The kneecap, he'll remember you for the rest of his life. Probably not be able to. By the way, the most sensitive part of the body is the kneecap. You shoot somebody in the kneecap and they're going to be suffering more than any other body shot. So, under the initial statutes, Title IV was the self-defense statutes. Even our self-defense statute is, they call it justification. It has a lot of different nuances to it. We could have an entire course just on what self-defense is in the criminal law. The Castle Doctrine is now in effect. It deals with your home, and it deals with your car, your business, and it includes the curtilage. So for all of you who are at home at night, realize that you have the right to protect not only yourself in the boundary of your home, you have a kill zone around your house. And I don't like using that word for lack of a better. You can't put mines or bamboo spikes or holes that people can fall into. That's not the idea here. The idea, and again, remember, you can't use the curtilage defense unless you have a no trespassing sign up. It has to clearly say no trespassing, even if you have a gate. You need to have that no trespassing sign up. For the curtilage, for your house, you don't need to have a no trespassing. Once they come through the window, they're fair game. And on the other side of it, it's good for all those criminals out there, all those meth addicts that think that they're going to get away with it. And that's why I did that billboard, to let the meth addicts know you should keep killing people like the Korean tourist and that Valentine's Day murder. 2 innocent people that were killed. Victimless, they're victims of a senseless crime. Okay? So, and that's where the Attorney General's office comes in. If I see a case like that, my prosecutors are already knowing that they need to come to the Attorney General when they see fact patterns, like the Kanata case where the officer should not have been charged, that he was vilified, charged, had to pay an attorney in order to defend themselves. That's the reality of life, ladies and gentlemen. When you go through the criminal justice system, you get raked through the coals. That Daniel Penny, when a vigilant U.S. Marine that did a chokehold that didn't kill the individual, but the individual died later with all the medical problems and things that he had, he was put through hell and he was made to suffer. That's why I will never go to New York if I can choose not to. That is the jury system. And you saw the jury eventually made the right decision, right? But what scared me was the jury was deadlocked on the manslaughter. They couldn't come to a verdict. So they had to do another trial. The judge said, wait a minute, we're just going to dismiss it. The prosecutor dismissed the first charge instead of having to retry it. That's why they tried to get him for the second charge on the Daniel Penny case. And that had no firearms, that had no Castle Doctrine protection. But it went back to this idea of self-defense. In that case, it wasn't even self-defense. It was defense of others. If you guys remember listening to it, the mentally disturbed guy came on the bus, or the train, what do you call that thing, subway, and then he started threatening everybody around him. Everybody was in fear. That is where, again, you step back a moment, look at the district attorney. Who in their right mind as the district attorney general, would have prosecuted that case when all the witnesses that were coming in were saying that we were fearful that this guy was going to kill us? So, okay, I'm at the 10:45 minute mark. This is going to be the most productive by you guys asking the questions on where you're concerned about. So, okay.
All right, let's give Attorney General Winter a round of applause. And as the AG mentioned, I guess this is really going to be the meatiest part of our discussion today. It's a Q&A. And before I start fielding the questions, again, I just want to reiterate who is joining us here today from the Attorney General's office. We have Assistant Chief Prosecutor Grant Bolden from our General Defense Division. Go ahead, raise your hands. We also have our Acting Deputy Attorney General, Lau Stamps, from our Government Corruption Division. And as well, joining the Attorney General is Assistant Attorney General Christopher Gray from the General Practice Division. All right, so we've identified everyone, so I'm going to go ahead and start fielding questions. Just go ahead and raise your hand and state your name and then state your question. We'll have one hand over there first. We'll try to get to everyone. We'll start from the back and then work over to you. Sir, just go ahead and state your name.
My name is Vincent Ugly. I live in High Pine area. We take wood. I across the area. The light will come to Castle Doctrine. During COVID, a lot of squatters in the area, a high risk crime area. Now, my question is, I don't have a gun carrying permit, my wife does. If somebody enters our house and I'm the one that used her gun, am I going to be convicted as a felon or because I'm a veteran, so I know how to use firearms more or less better than my wife. But I don't have a permit because the FBI said I can't because of my PTSD and the medication I paid for. So I be prosecuted for taking our home, saying my wife's gun, but I don't have a permit.
Well, you know, it's interesting that you mentioned that, Mr. Ogden, because Grant and I were just speaking before this gathering about people that are being caught with their firearm in their car, but they only have a non-concealed firearms permit. Because technically, I think you're supposed to take the clip out, put it in the trunk when you have a non-concealed firearms permit. But if you get a concealed firearms permit, obviously you can keep it in your cab and so forth. Which kind of goes back to that little imaging that we have there where the woman has a firearm. Let's just say that the woman has a firearm, she had it in her purse, meth comes up to her and tries to rob her, and she only had a non-concealed firearms permit. The AG's office would probably say, we're not going to charge you, Ms. Jones or Ms. Ogden or whoever the individual is. Because that's the reality. If I took it before you, how many of you would charge her for not having a firearms permit? And she was faced with a meth addict or somebody that you can establish on that billboard. I'm sorry, it's our miniature billboard. If you see it, it's the one where on this one, this was meant to communicate something to our community and to scare the meth addicts. That if you guys think that you can be shooting people, get ready because they may be shooting back. If she didn't have a firearms permit and she pulled her firearm out of her, she didn't have a firearms permit or she didn't have a concealed firearms permit, would you as a juror convict her? Probably not. Okay? At least 12 of you couldn't unanimously. There's usually one person that just basically ain't going to change. I think that's what they had on the Daniel Penny case. Hell no, I'm not going to convict this person. That's why you get a mistrial, by the way. It's not all acquit, it's not all convict. So the judge has to either do the new trial, or in that case, the prosecutor just dismissed the first one and asked them to deliberate on the second one. That's what, Mr. Alvin, you're facing. I can't say as an attorney general, sir, that you're going to know where your firearm is, and then just because it's your wife, that you're just going to go grab it if you need it. But if the facts played out, and again, it's all fact specific, if it played out in a way that a reasonable juror, which is all of you, would say that this person was threatened, these people came into his house, this and that. So technically, we could charge you with, not having a firearms permit, that sort of thing, which is a felony. So we could try to get 3 years in jail for you. But with this AG, would my prosecutors do it? Hell no. And if I found out that somebody filed it, like we did on the Kanaka case, I would just get dismissed. You know, because the office is too big for me to know everything that's going on in it. But that's why you have an elected attorney general that manages his law firm, that eventually comes up to the attorney general. I read it in the newspapers, which our media is excellent for identifying all these cases going on. I often talk to my prosecutors, what's this about, when I see it in the news. So I hope I answered your question. And by the way, one of the things I also want to say, so in case any of the creative defense attorneys try to use this against us, this is just a discussion, but every case will turn on its facts. And the law could change tomorrow. We saw that with the Castle Doctrine, with the John case that came down in 2016, where they said it was the privilege, so no Castle Doctrine. Senator Parkinson, in his public hearing, decided to include the curtilage in it, and that is our law today. By the way, we had one more case, by the way, on the Mendiola case. Again, in the 2 cases that I've seen, the homeowner was killed. It wasn't where the homeowner is being tried as the murderer of killing the assailant. The person that came to the house was the one that was being charged in both those cases. So it's, when you're dealing with cases, a lot of it's logic and following the storyline of what happened. So, good question, Mr. Augie. Is there another question?
All right, thank you, Mr. Augie. I'm going to go ahead and have the microphone over here. We're going to work our way towards the front. So, I have questions in mind already. Go ahead, identify yourself.
My name is Paul Kerner. I was listening to you saying like the threat is coming onto your home. It's best to shoot them in the May, not in center mass, but during the time of the invasion, you only have so much time. It might be dark, and you recommend to wound them, but I think it would be harder to shoot that person in the leg or the arm instead of center mass.
Or miss and hit a family member.
Or miss or over penetration. So, what do you recommend? Because you only have seconds.
Okay, well, let's put the fact pattern. The person is at nighttime, and you decide not to do the, what I kind of suggest. You hit him in the heart and take him out immediately. Under my reading of the law, you would not be charged at all. So, yeah. I'm just saying that, what if you found out that it was your neighbor or you... Yeah, what was that one with Clint Eastwood, that movie where, was the recent one where he shot the guy? The idea, guys, is that, what if you find out in the darkness of night, when you find out the person that broke your window was really the kid that you, was the guy that does your lawn, the teenager next door, and you just killed him? That's all I'm saying. You have the right. You have a right, whether you choose to use that right. I say, please think like I know you all think, very carefully. And that's why I say that the firearm is a tool. People that have shotguns as their home defense, that thing's, it has a spread pattern. So that means that if you try to shotgun somebody in the house, you better hope your kid's not next to that person. It's common sense, right? It's this idea that all you jurors, when you're listening to these facts, and that's what a trial is, ladies and gentlemen. It's a story. And by the way, another reason why you want to sit on a jury is that you want to listen to what's going on in our community. The duty of the attorney generals, the prosecutors in our office, is to tell you a story and to hope that you see it our way as storytellers. That's really what a trial is. You're sitting down and listening to a story.
Thank you. Can I ask you one more question? So self-defense from your vehicle. If somebody was pounding on your car or your window, and you feel like the guy's trying to break in, can you use deadly force?
I don't think that that's the reading of it, and it's a good question, because what do you do in the car? We saw what happened recently with the guy that was trying to take the car, and the family was inside, meth addicts, right? I believe. He ran to Jonestown or something. Again, GPD, excellent. They caught him. I think they caught one of them, and the other one they quickly got after. What do you do in a situation like that? I don't think, well, there's no curtilage on a car. Okay, so there's no, 10 feet around the car, stay away from the curtilage. I think you have to get to the car. You have to come into the car. Yeah. So you can't, the person pounding on the panhandler. No, you cannot shoot the panhandler.
We'll leave that to the time listeners. All right,
That's why we got those guys.
Okay, that's the trouble. Oh, yes, Jeff. Please.
Yes, first is right out of Okay, I'm sitting at home in my garage. I have no trespassing sign on my front gate. And as I was sitting there, this guy came down the hill and you could see the kid. I don't know him from Adam, walked up right up into my garage. I was shocked. And my question is this, in a situation like that, the guy that came from me, down the hill, through the gate, in my garage. What would you do in a situation like that? And the second question, the follow-up question is, when you go to the police department, let's say you do protect yourself with a firearm or a knife, and you want the police department to show up, we confiscate weapons, all the weapons.
So this is one of those very fact-dependent kind of circumstances where you weigh all of the factors. Is this during the daytime? Is it at night? Was the lighting situation like? Did you have opportunity to observe this individual as he was coming onto your property towards the garage? Was he armed? Was he not armed? Was he making threats toward you? Was he running towards you, or was he simply walking? All of these factors would be taken into consideration. And I think it's important here that when you're reacting to these situations, that use common sense. Be smart about the situations. You're not going to, in those particular circumstances where you have an opportunity, someone's on your curtilage, you have an opportunity to observe them, their appearance, their demeanor, how they're acting. You can take those considerations into account when you're making a determination of if they're really an imminent threat to you, to your safety. And the key here is that it has to be reasonable when you're acting. So just keep that in mind. In those particular circumstances, there's a lot of gray there, and I wouldn't necessarily say that if you were to react in a way, using defensive force in that particular context, you wouldn't necessarily be protected from Castle Doctrine, depending on what they're there for. Because maybe they have a legitimate reason to go there to visit you. Maybe they're, a religious pilgrim, or they're delivering something, or So you have to be smart. Obviously.
Exactly. And just to interject real quick, remember the curtilage is recognized in the law, and the chief and his troops always use the curtilage. People are protected to go through your gate and up to your front door and knock. In the law, the court cases talk about the curtilage, but this is a right that everybody has a right to do. Your neighbors, when you have no doorbell and you need to go talk to them, and their gate is open, or you open the gate, or they have no gate at all, you have a right to walk up to people's door and knock. And that's why it's important that when we talk about fact-specific, because you're dealing with what is common sense in the community. Hey, even at 2 o'clock at night, I saw somebody prowling your house, and you walk into their curtilage and you're going up to the door. That's why it's dangerous. The Castle Doctrine is not a right of execution, okay? And that's why you guys got to listen to the facts and just think about how would you feel in a situation if you were put on trial for that. Do you have enough facts on your side to show that it was a dangerous situation, I needed to pull a firearm out?
And obviously, we're going to give a lot more deference if someone's in your home and you're caught by surprise and you act using deadly force. So yes, everything is fact. And you also asked about confiscating weapons. It's important to know that in the Castle Doctrine statute, if the police, if there's reason to believe that you were protecting your property or yourself, then the police can't even detain you, let alone arrest you, and you can't be criminally prosecuted. In that particular context, then your weapons wouldn't be confiscated.
Right. Potentially not, but and I know how much we all love our guns, but they scratch it. But I mean, the idea is, I think that they might be able to do that under the administrative authority. But it was interesting what Grant just mentioned. The statute specifically says they cannot arrest you. Okay? So you have this right of protection if all the facts are in your favor, sort of thing. At night, and the person's dead body is there, and the cops are questioning you. Unless they can show something special, you cannot be arrested. And what's even more I wanted to talk about, there's a provision in the statute that Senator Parkinson, I presume, put in. You don't even get to go to a jury. If you're being accused of something, you have a right to ask the judge to throw the case out. Just say that you're the one that's being charged. You're the homeowner, you shot somebody, AG's office decided to prosecute you. You have a right with your defense attorney to not even go all the way to trial on it. You can just immediately raise the self-defense, which once it meets the basic criteria for what self-defense is, it becomes the people of Guam's duty to prove beyond, you've got preponderance of the evidence, clear and convincing, and then beyond the reasonable doubt. Those are the 3 legal standards in the law. The AG's office has to prove by a preponderance of the evidence, which is harder for the people to prove, that you didn't get the protection. Yeah, that's right. The preponderance is a 50% over. The clear and convincing is the one between the reasonable doubt one. So the clear and convincing, we have to prove, the people have to prove, clear and convincing that you weren't righteous in how you approached it. And that's up to a judge, by the way. So the judge can just throw the case out immediately.
Well, you have video cameras in your garage.
All fact specific. All fact specific.
Did we answer your question, sir?
What about the sign?
The no trespassing sign?
Has to be up.
The other kind of sign that you have.
Cannot use the way I'm reading it right now, that you have a gate, you have coconuts on your boundary, whatever, it has to have a no trespassing sign somewhere. And it can't be in the back of the house. It has to be reasonable notice.
I'm going to go ahead.
My name is Irene Serpato, and I'm from Arizona. My question is more about, it's similar to the cartilage,
Privilege, right?
privilege, and I guess they have no trespassing sign. So let's say your house is fully fenced. Are there regulations or some kind of guidelines for where these no trespassing signs should be placed around your house or fence? And should they be registered somewhere at a government agency or not?
Hello, sorry. As far as what has been kind of said to everyone, it's fact specific. Use common sense. I mean, the plain answer to that question would be no. The big thing that the AG had said to earlier is reasonable notice. So reasonable notice, like your trespassing sign cannot be in the back of your house. It can't be like a worn out sign. It has to be visible and clearly reasonable. So if somebody walked by, they could see for a fact that it is a no trespassing.
And you know, quite frankly, I would have no problem. No trespassing, trespassers will be shot. You know, that way the jury's not going to have any misconception. No. They know exactly what they're saying.
That's very clear, as the agent said.
Just making
Is there a quantity or just one will do?
It's reasonable notice.
The statute doesn't say that.
There's not specific on how many, it doesn't say it's one or two. It has to be common sense if I'm walking by, or if your neighbor's walking by. Think of this, their neighbor was walking by, the friendly people that you deal with, do they know that that notice is there? Would you know that a notice is there? Think of it that way, would you know that a notice is there?
Thank you.
Morning, my name is Steve Cruz. I want to ask you a question now. Do you need a firearms ID or a concealed license or open carry license to defend yourself from your family home? Okay, say I leave my wife home with my kids, right? Okay, by law, your firearms, your guns, everyone knows they're supposed to be locked up in a locker, right? Say I go to work, someone breaks into the house and they kick down the back door. Armed with a knife, maybe machete. My wife knows where the keys are to my gun, right? So she gets my gun, she shoots the perpetrator. Just like, for instance, the gentleman's question here. He's retired military, right? PTSD, you know. Okay, he's being attacked. So I heard the gentleman say that he might be charged without having a firearms ID, right? But so it's just like, for instance, I can take anyone in this room right now to the telephone shooting range, and I can make them shoot my gun without a firearms ID, without a license. So my question is, everyone in this room who don't have a firearms ID, right, whether it be a male or a female, if she was left behind, I went to work, someone kicked down the door, she took my gun out, she shot the perpetrator, she killed him. Will my wife, will be that husband or that son or that child be charged with not having a firearms ID? Number two, one of your illustrations in the front, I think that car, you took out a gun, right? And I think you mentioned, if I heard it right, will you guys prosecute her? Maybe not. But she didn't have a firearm. Why did she have a gun in the car?
Right.
So it's kind of conflicting. So, you know, is it fair to say that we can still defend ourselves, you know, and our family in the house? Say we leave our guns and our kids know where our guns are at. If someone breaks in, so you're gonna put my wife or the husband in jail because they defended themselves in their home. They don't,
Okay, well, let's kind of break that apart, okay? So first, you got the legislature, right? They're passing laws that were intended to protect us. That if you have a firearm, you have to have it registered, the firearm got to be registered, then you need a license in order to touch that firearm, right? So those laws were passed for certain reasons, to protect the kids, to protect people in general. We don't like it when firearms are going around killing people and we don't know who has them, that sort of thing. That's what the law is. Okay, as a Attorney General, the Attorney General's primary duty is to enforce the law. Okay? But at the same time, you're raising another fact that's overlaid on it. You're put in an emergency situation. They call it necessity to protect. Protecting life is always above all other considerations, right? Not taking life, but protecting life. Like I opened up, life is precious. In your situation, the person is justified to protect themselves by using a firearm that they're not allowed to use, like Mr. Hodges' situation. Whether the AG's office will prosecute the person for not having a firearms ID when they had it. First of all, that is the law. Second of all, prosecutorial discretion. The Attorney General is responsible for deciding what cases to prosecute or not prosecute, right? So you elect a good Attorney General. The Attorney General uses common sense like all of us have in the room, and they're not wasting our taxpayer money chasing that thing. Third thing is, I put it before you guys. Am I going to get a conviction? No. It's called jury nullification. That is where your wife may have violated the law, but when the jury hears the story, they're just going to shake their head. We've had good and bad my whole career. I've seen juries just walk out and come right back in. I've been like halfway to my house as a defense attorney, and they come back in and, you know, not guilty for my client. And our prosecutors, we've got a winning team of prosecutors. A lot of the jury verdicts that are coming in, they just walk right out of the jury box and come back in within 15 minutes. Guilty. That is the beauty of the jury system. You guys decide what laws you're going to enforce. The judge is going to tell you, if you find that this woman didn't have her firearms ID and she picked up that gun and shot the person, you must convict her for a firearms ID violation. You guys going to convict her? Probably not. Is the judge going to get pissed off at you? Cannot. That is the jury nullification. You violated the law, but no jury is going to convict you. And as an attorney, you want an attorney to look at the future. You know, I'm never going to get a conviction on this. So, yes, that's it.
Thank you, Joe. I know, first of all, thanks to you and your staff to have us, have this opportunity to be here, sort of a mayor. My question is pertaining to the most recent home invasion shooting at Alameda Street in Denver. I'm sure that a lot of you folks know about this.
Yes.
From what I read is the person, well, the case is classified as a homicide, correct? Based on the news.
Well, I'm not going to put the chief on the line for this, but we also have Chief Ignacio. But yeah, I'm aware of the shooting.
Okay.
If the chief wants to contribute.
So obviously that happened like 3 months ago, 4 months ago, and I'm just thinking about the point of view of the individual who has to pull the trigger to defend himself as well as his family. So if the case is still classified as a homicide, I can already imagine the shooter having to do what he has to do to protect himself and the family. I can imagine the mental stress that he's going through because the government
is still classifying it as a homicide. I mean, I can imagine he's thinking, are they gonna knock on my door and say, it's not a justifiable homicide? Or did the office send him a letter and say, prosecution declined?
Okay.
I'm just thinking about the stress the family's going through, as well as the gentleman.
Absolutely. So, by the way, this is a good friend of mine, Ed Tovis, from the retired Chief Marshal Superior Court. So, a lot of my career, I was the chief there. That's a very good question. Let me kind of break that thing apart. I told my prosecutors, because facts, we don't, at the AG's office, we get everything from the good officers with the chief of police. We get these police reports, and even when we get the police reports, we send out further requests for investigation, either with our team of AG investigators or requests that the chief's specialists or detectives get us more information. I do not, as a policy, ever tell anybody that they're not going to be prosecuted. Because when I do that, it's like what happened to Bill Crosby. You see how he was convicted by the jury, but then they reversed it on appeal on those rape charges because he had made a deal with the prosecutor that they weren't going to charge it, but there's no prosecution declination. It is not in the people of Guam's best interest to be telling people in advance during the statute of limitation period that we're not going to prosecute you. That's a danger, because what happens if new evidence comes in that finds out that the facts that we thought were in the police report weren't actually there, or the person who told us something was lying. So, yeah, and in terms of a policy from the AG's office, I do not sign any, unless there's specific certain circumstances, so I'll just caveat that way, but as a normal routine, we never tell anybody that during their statute of limitations period, and the military is always asking us for that, by the way. We will not tell them that they're not going to be prosecuted. Because what about the crime victim's family? When they find out some information, that sort of thing. So what you're saying there, I contrast to what the Daniel Penny, the guy that strangled that subway person, he went through the hell of having to get an attorney and having to potentially lose his liberty by a jury. In your fact situation, the person that was shot in that situation, in the homeowner, I believe that the chief's people, their detectives, already decided probable cause existed for the shooting, and they decided not to send it to our office as a homicide. But it is a homicide. Whether the person was rightfully shot or not, it's a death of a person. So I hope I'm trying to end. These are the nuances that I'm talking logistics with you when I say these things.
Yeah, I'm just concerned because it could happen to anybody in this room,
Right.
who has the right to defend themselves and their family. Just moving forward, everyone in this room needs to understand that if they shoot and kill somebody,
The case is still gonna be considered as a homicide.
Right.
And then you knock on my door a year later and say, hey,
Exactly.
we're gonna charge you.
So what you're saying is very good, because there is no statute of limitations for murder. So that means that 30 years from now, some attorney general, because of some evidence, could charge the person.
Is there anything preventing the police department, the investigators, to say, hey, Doug and your staff, we've done an investigation and we feel that this is a justifiable homicide? Do they forward that, or they just say it's a homicide?
Well, at the AG's office, what we do internally, there is a determination, and I've got my lead investigator here right now. They usually make a determination on whether we're going to pursue the case, okay? But saying that whether we pursue it or not is different than saying that we will not pursue it because we don't find anything wrong with it. That's where, as an attorney general, I'm very wary of that, because, again, if you find out information that the person actually did execute this person, you know, for some reason, like it was a drug deal gone bad, that was the supplier that came in and he popped him, even though he was in his house, that sort of thing. That's why it's very dangerous in saying we're not going to prosecute somebody. And the best thing is, rely upon the facts, rely upon the Castle Doctrine, rely upon the statutes, and the integrity of the facts. So it's just one of those, it's hard to say you are forever forgiven. It's one of those things that just hangs over a person's head, that they were in quite frankly, and you know this, within 6-month period after a lot of these cases are wrapped up, if you're not charged, you're never going to be charged, because there was a reason why you were charged.
Yeah, I'm just wondering because of the statute, I mean, correct me if I'm wrong, all statutes, does it have anything that, any definition for justifiable homicide? I know they have a definition for homicide, but
Right.
all justifiable
Right,
homicide.
exactly. And that's why we go back to this idea, when you say self-defense, my idea of self-defense may be different than your idea of self-defense. But how do you determine that? You gotta go to a jury trial. So, you know, it's kind of like, that's the way our system is structured, but for the Attorney General to make a final determination and forever dispense a homicide in that category, it's dangerous for the people of Guam, and especially it's an injustice to the victim, who actually, or the supposed victim, who actually may have truly been a victim of the murder.
Yeah, I'm also, one more question, maybe the chief of police can answer this question. If his investigators feel based on the evidence and witnesses at the scene that is justifiable, are they conveying that message to your staff?
Actually, good morning, everybody. So thank you for that question. So yes, as you see with the last case that you referenced in Guerrero, our job is to investigate the case, determine all the facts, interview all the witnesses, collect the evidence, and just send it up to the Attorney General's office. So you are right. When somebody does kill someone else, it is a homicide. Because there's only 5 classifications of death: unknown, natural, homicide, suicide, and sorry, the fifth one is manslaughter. No, manslaughter is homicide. Any killing of an individual by another individual is a homicide. Yeah. Then there's the suicides, is the natural, then the undetermined, right? So in that case that you referenced in Guerrero, our job again, just like any other case, is to conduct an investigation, determine the facts based on the witnesses and the evidence gathered. And if enough probable cause exists, then an arrest is made. But I will tell you that every death investigation which is determined to be a homicide, we immediately start coordination with the Attorney General's office, the AG himself, or one of his prosecutors. We make contact and present the case to them, and we work in conjunction to determine if an arrest is made. So you got to remember, right? That's the definition of what we call the homicide. Because, like in that case, and even police officers, believe it or not, when we shoot and kill people, that is considered a homicide. Case in point, the Tato case in Tumunica 2019, right? But they were investigated just like any other person in this room, and we packaged the case, presented it to the Attorney General's office, presented it to the FBI and the U.S. Attorney, and in that case, the officers were not charged, right? So it's still a homicide because the officers killed someone.
Just for everybody in the room to understand that if they ever shoot or kill somebody because they want to defend themselves in their house, that not to feel bad, I guess, that they're categorizing the incident as a homicide. And
I'm sure it definitely will be categorized as a homicide.
yeah, maybe I don't know, maybe I gotta go back to Title IX, but maybe there is something there that says justifiable homicide. I don't know, maybe your attorneys can pull out the,
Well, there will be the self-defense statute, the Castle Doctrine statute will be applied.
so long as everybody understands here that, hey, you shoot somebody, you're gonna undergo the same defense as one goes through.
Yeah,
When you wake up and say, man, they categorize it as a homicide. When are they gonna give me that, where are they gonna throw in that word in front of homicide and say it's justifiable, Ed or Steve? You know, so I'm just letting everybody know.
You raise a very good point. It's just one of those situations that, you know, we're not perfect in life, and I all people. We make mistakes, so I think it's better just to just say that you haven't been charged, and sometimes we can't say based on the evidence, we don't intend to charge you.
I guess after the 6 months ends the day of suspense, that's when you can stop drinking your beer. Anyways, but hey,
Everybody goes through stress differently, right?
Right.
You know, and you can have this single 50-year-old lady who's taking care of her first 3 kids by herself, and you know, maybe she's just nervous every day because am I going to get charged?
Right.
Even if I know I did the right thing.
Sometimes meeting with the AG or a person I appoint, a prosecutor, they usually kind of talk to them and may say something to them with a defense attorney, and that it's usually they don't have an attorney yet. So whether it's the police that kind of talk to them at the scene or office when they talk to the homeowner, it's usually they'll get some sort of an informal, we don't think this should be charged at this time, based on all the evidence. A lot of it, you rely upon the truth, ladies and gentlemen. You were there. I find that as our prosecutors will say, usually you can tell when a person's lying because they can never get it straight. There's always a little bit of wiggle room in how they say the facts, but if you're telling the truth, your mind always goes back to the truth. And our team of investigators, the police, a lot of what we do in the AG's office is, what do you think? And so they ask the officer, what do you think? I think this person's lying, or I think this person is telling the truth. It's really how you present yourself and what happened in the facts. Is there any other questions that we have?
Yes. First I'd like to thank you for using your common sense, and I hope that every AG after you does the same thing. And I thank you for being tough, and I thank you for doing what you do and your ideals. But my question is, there's a lot of us farmers that have the same situation where we're threatened on our own property. Many of us have fences. I personally have a 6-foot fence all around my farm. Have no trespassing signs every 100 feet. Have a lock gate. Yet I still have gangs of people come, cut the fence, come in and steal our crops or threaten family members. Now the curtilage law is not clear, but is there any determination of how big the property has to be, or if it's defined by a lot number?
Let's put it this way: the curtilage law is kind of clear. It's just the danger of what you're going to be doing in that curtilage and you're raising this idea of you're a farm owner, okay?
Correct.
So by the way, the curtilage also applies to businesses. So in a farm owner's situation, so this idea of curtilage that we're talking about, you have the no trespassing signs. You're saying that people are coming in the daytime. You know,
nighttime too.
Okay, well let's just take the daytime situation. You see the guy in your yard, and he's jumped your fence. What I would do is I'd fire a round up and then give him a warning as opposed to take him out immediately, right? By the way, that common law thing I'm talking about, you cannot use deadly force to protect your property. Okay? That's one of the common law rules, is that a person is coming in to take your kid's bike before the Castle Doctrine. They're coming in, they got their bolt cutter, they're cutting the lock on the bike, and he's trying to get out of there. You can't take your sniper scope and then take him out right before he gets out the property. That's before the Castle Doctrine. With the Castle Doctrine, there's this presumption that you can use deadly force. That's why I'm worried about that. The castle, the use of the curtilage. In your house is one thing. There's a presumption. You're old enough to jump into my house, so you deserve what you get. That's the Castle Doctrine. But if you're old enough to jump, to steal some,
But it's not that. It's the threat of life.
Right, but you see, in the fact situation, it goes down to the fact that when the chief goes there with the officers, they're going to be asking the question, did you have your scope mounted so you're going to shoot anyone within that kill zone? Or did this person, come in at night and your house had been robbed a few times, I guess, or burglarized a few times? Every fact is going to play into an attorney general deciding if it's going to be going forward, whether the judge is going to give you the ability to have the case dismissed, and then ultimately whether the jury is going to decide if it was righteous and how you shot that person. So, it's hard for me. Can you go forward on your facts?
Let me straighten this out. So many years ago, this happened several times. A farmer's out on his farm. he's got a fenced area, he's got dogs, they will still come in and threaten the farmer to kill him if they aren't not allowed to, take all your goods, basically. Now, where's the determination? Are we still using the common sense?
Well, you just gave something that the jury will apply. That person has before threatened me. If that guy, we have that, by the way, I see all the police reports almost every day, the family fighting that goes on, that this person has made a verbal threat, there's witnesses to that.
Right.
He's now coming to your kill zone, your curtilage. And again, if it's at night and he's coming there, and especially if he's got a weapon, if he's got his own firearm,
That's correct.
usually what you do is you say, drop it, get out, and if he doesn't, then you drop it. But I mean, that's what the Castle Doctrine says. It's your curtilage. You have the right to use deadly force. It's the presumption, okay? The presumption.
So what you're saying is, if those conditions are met, and everything is followed like that, then that idea of common sense and curtilage and everything will fall into place. Am I correct?
When you say common sense, it worries me. Because my idea of
Well,
common
he's
sense...
threatening you. He's going to kill you.
Yeah.
What are you going to do?
But you see, that's your facts. And you're talking to a guy that's got a conservative background. But you get some liberals together, beware. Because they may say...
Yeah, I'm just saying, because there's a lot of farmers that are scared to death that they're going to go to prison. Or be killed.
If you're building a case to it, that's where you call the cop the first 2 times.
They don't show up.
Well,
They don't show up, I'll be honest with you. And he can check his records. Then the precinct will tell you right away. If you don't have an idea who the person is, we can't
Right.
do that.
So
Anything on private property, we don't want to investigate.
for you guys listening to it, for the people like yourself listening to it, you document. I called the cops on this date, I called the cops on this date, and then he did it again. That helps on understanding.
Well, that's the reason why a lot of farmers are questioning this, and they're really worried because the criminal element has gotten unchecked basically in the situation. And so now where are our rights? Are we going to be a victim of a homicide? Or are we going to be proactive and, like you said, fire a shot? What does it take? I mean, we got to draw a line here. And that's where, like you said, it gets dangerous, but I appreciate your common sense and your thought about building a case. And I can see that. But there's a lot of people that it's too unclear. There needs to be, you need to get tough and you need to say, well, we're going to look at this way or that way. And if the word gets out, then it might change the community, it might make it a safer community, and I appreciate that.
Sir, thank you for your question. I just kind of want to give a little bit of a clarification of privilege because, so the courts are very broad in that definition, but the legislature has made it very specific. So we'll kind of walk through a couple of those things. First thing is, how immediate is the area? So think of it this way, how close is it to your door? I mean, if you're describing a property that's just 10 miles, how close to the door versus to the edge of the 10-mile property. So that's another factor. The language is specific that it says is within an immediate area. Okay. The other big thing is the purpose of the area that we're discussing here. The language is it necessary or convenient at your family purpose? What that means basically is, does your kids play there? Or are you using this area where you're parking your car? So like we've been mentioning, it's fact specific, right? The other thing that we've talked about is it enclosed, there's no trespassing signs. But think of it that way. Like, is the area, it's an extension of the home? Is it the place where your kids are playing at, where you yourselves are using the purpose of the house? But if you have just, like, you're storing it like your storage place, I mean, that's where the fact specific starts to change in the courts and our office, of course, will look at it a little differently than the police looks at it. Does that help a little bit?
So, pull up the definition of privilege. So the statutory definition of curtilage under the Castle Doctrine says it means the area immediately surrounding a residence that is necessary, convenient, and habitually used for family purposes and for those activities associated with the sanctity of a person's home. Now, this is where the argument's going to be for the defense attorney and the prosecutors charged it, that the large plantation wasn't the sanctity of a person's home, those activities associated with sanctity.
But it could be a business.
But you see, that's where the person would come in and argue, no, my kids play in this farm, and that is the curtilage of our home. This is, we're farmers, this is our home. We've got our chickens there, we've got the, that's the type of, that's why it's dangerous on the curtilage. It's good for the homeowner that shoots the guy, but for the guy's point of view, the guy, when that's shot, their family is going to be arguing that he was killed in cold blood, that he was executed. So, and that's why I go back. Using deadly force to protect your property is not traditionally authorized. You cannot kill somebody, use deadly force to protect your cassette player. So, yeah, that's where the lawyers make their money.
But on the position of the tough AG, would you prosecute somebody if I was there?
There would be, I'm sorry, your last name, sir, is Mr.
My name is Eddie Cruz.
Mr. Cruz, yeah, that's right, I think I mentioned before. Mr. Cruz, you've got an AG that's going to bend over backwards to look at the facts. If life was in danger, if this person threatened you in the past and it was a real bona fide threat,
right?
Even family members, I know that a lot of the family members, they get really hostile with one another. They have no problem beating them up in public. You know what I mean? You get the facts straight, and the AG's office could decide not to prosecute it. Okay?
Thank you.
So thank you.
That's what I wanted.
Do we have one more question?
And just real briefly to add on to that, for everyone, beyond Mr. Cruz raises a point, then I can hear his frustration. And if anyone else has been in that situation, then we want you to know that we hear you, and the chief does too. If you called out and you asked for the police to come out, right, they may be overworked at that time, for whatever reason, right? But there's nothing that stops you from going into your local station or going to the main station if it's an ongoing problem and letting them know. And you could go to the station, you could make the report, you don't have to wait for the police to come to you. You can do that. And in a situation like that, as the general said, you need to do that to build that record so that when something happens, we see, oh, there have been multiple reports here that these people are bothering this farmer and they've stolen from him before. It was just trying to defend itself.
That's exactly what I wanted you guys to say. To let the people know that that's the position. And that's part of the facts of helping them to defend themselves.
Thank you, sir. Thank you. Good question.
Hi, my name is Linda, and I have a business question. I'm soon to open a business. The question is, if somebody comes in and tries to rob me, but my son in the background, he's a licensed gun, and he comes out, and the person's trying to rob me, sticks a gun in my face.
Right.
And my son comes out in the back and shoots the guy.
Right.
Is that justified?
Right now, your fact pattern is protection of another. And quite frankly, even without the Castle Doctrine, you have an AG that would probably look at it and says, what was he doing to you? You know, that sort of thing. So, in your fact pattern, you would not charge a case like that. Yeah, thank you.
Any more questions on this side?
This is not pertaining to Castle law. Say you're out in public, coming out of a shopping center. Is there a 21-foot rule for self-defense? I mean, that's crazy. So
Why is 21 so important to you?
Excuse me?
No, I was going to say, why was 21 feet so important to you? Is this a pending police report? I was just kidding. But no, I'm not aware of a 21-foot rule. But unless you're the Castle Doctrine under Title or Article 5 of
I just said this thing's about Castle Doctrine.
Right. So it goes to the Article 4, the self-defense provision, which has been the law for the longest time. So continue.
Okay, 21 rule is like if somebody's threatening me and they're within 21 feet and I try to avoid it and turn around and say, sir,
do not approach me, stay away from me. But if he continues to come forward and he pulls out a knife, he's within 21 feet. With some states, you're allowed to pull the weapon and just fire at it.
I think I know where you got that from. And the training, they talked about the training, and I want to say that I think it was Ed Tobin's group that did that training. There's for protection specialists, they talk about the amount of space that a person needs in order to respond safely. So I don't know if it's 21 feet, but I know that the distance, there's a distance issue. So when you shoot a person, that doesn't necessarily mean that the person's going to be dropped. Even with the 22 versus the 45, there's different ways that the person can continue to come at you. So it's going to come down to the reasonableness. The jury may hear the experts come in and say that you needed to shoot that person at that distance in order to protect yourself. I think your fact pattern that they have a knife, that's dead, that's deadly. So that raises from factors with deadly response.
Okay, say you don't brandish a knife or a gun, you don't know if he has one, and then he plans to.
You can't pull your gun out and just drop it. Just because he's coming at you with his fist, that's not.
What if I'm a disabled person, my body's so broken, I'm not young like before, I can wrestle 3-4 guys, and then go out. I'm a senior citizen, I got spinal problems, if I tweak the wrong way, I can go down and get paralyzed. Am I going to jeopardize that because they expect me to do this MMA crap?
Okay. See, again, it's a fact-specific case. If you're talking, the AG's office is going to charge it. If you're in a wheelchair and the person is coming to pummel you,
so I have my wheelchair around? That's what I have to do, then I'll do that.
well, guys,
Just tell me, what do I have to do? I'll get my wheelchair, myself.
I bet you, if we asked that question, asked you all to raise your hands on whether you thought that was justifiable or not, you may not get the full consensus that we would need if taken to trial.
But just the verbal threat, am I going to take that serious or am I like, okay, I don't see nothing? But am I going to subject myself to pain? And maybe the guys, you're going to see these guys come in, they knock you off, you hit the floor, you're dead because you get, I don't know.
Right.
Knock your brains out? Am I going to wait till that?
So we go back to that default statement that I said, in common law and kind of reflected in our statutes, if they're using deadly force in a deadly situation like coming at you, you have the right to respond with deadly force. If they're using non-deadly force and coming at you, you cannot escalate it to a deadly force situation. That's the normal general rule that we lawyers can
Even though I go ahead and decide to shoot them on the leg so they will stop me from force.
I think that
I don't want anybody to inflict pain.
if you
Truthfully, there was an attempted robbery on myself. Three of my Venetians tried to rob me after Labor Day. They cracked my head in half. If I had my gun, they would have been dead by now.
Do any of you remember the Getz shooting in New York back in the 80s?
Yes.
80s? I think it was the 80s. Do you remember that?
No.
Where the guy was in a subway, New York subway again, and he had like a firearms. There was the whole litany of people that were getting mugged on the subways, right? So that was a fact pattern there. So he felt that he was going to be potentially mugged. He had a firearm. I don't think that the guy had a firearm. He shot. They prosecuted him, but they did not convict him. So what your fact is, you're saying a lot of things that may resonate with people. That, hey, you know, I'm very scared. I'm not a very big person. I need some protection. I shot him because I felt worried. That's where you get in that little gray area where the AG may have to bring a case in order to let the jury decide. And you got to be careful because on the other side of the equation, you've got my uncle or my brother was mentally disturbed. He didn't deserve to die. He had no weapon on him. You could have just punched him in the face. You know what I mean? It gets into that fact specifics. The AG's office will have to look at it. Sorry, I can't give you the equation. These are all human.
No, it's okay. It's okay. I'm just going to go get my wheelchair. Take your chance. Take your chance, buddy. I'm on a wheelchair. What if you did it on camera? What if I put it on my cell phone? And I've been arguing with that. Anyway, we get to avoid the violence. I And I say my car's 200 feet away, and if I start running like my doctor said, and I pull my back, I'm down for count. So why should I have to suffer that and have to avoid this guy if I know he's threatening me or going to kill me? I'm shit out of luck.
You're gonna roll the dice in front of a jury. That potentially is the danger.
Okay, I'll take my chance.
That's the danger.
Thank you, sir. We just have our questions long, so,
Thank you, great. I gotta go flip my wheelchair.
You want to come up back?
Yes, sir.
The question is very deep. My name is Dan. I'm asking this. In a condominium project, multiple unit owners, one set of common areas, like a parking lot, lobby, swimming pool, are those that are not considered pertinent?
Currently, there's an area immediately surrounding the residence that is necessary. So the common areas are for everybody in the building, right? So in a fact-specific case, it would be that particular condo. So I would think it would have to be immediately, well, again, it may not even involve with it because it requires a notice to be posted by the owner. So it may have a problem on the condo situation or an apartment.
Multiple owners.
Yeah.
We own the common area.
Yeah.
So that's our backyard, each of us.
See, the statute doesn't specifically address that. It will probably be subject to a motion that the judge will have to interpret what the senators meant. Thank you.
How did you take a chance to be?
Thank you. Maybe two-part question. I just want to confirm. So you got two-person household, me and my spouse. When I was working on lawn all day, he's retired, and I'm more worried for him than I would be being home alone. The gun is in the home, and he's going to be home by himself all the time. If he did not have his firearms, basically, if he had to defend himself, he should be cleared and good to go if it didn't justify.
Realize that as I started off, this is not a firearm statute. This is the use of deadly force. So whether you use a machete, a crossbow, or anything that's a deadly weapon is a separate question. So in your situation, your husband would have the right to defend himself, use deadly force. It's in his home. So anyone that would be in there would be subject to being shot, killed, maimed, whatever, with whatever type of weapon is in there. A firearm, if he used a firearm, goes back to Mr. Huggins' question, that we wouldn't charge him. But the facts have to exist. It can't be an execution, and that's where, if it was an execution, then the agent's office would probably charge the crime and the use of not having the firearms determined, that sort of thing. But,
Yeah, so, we got self-protection, we have, in fact, we have a gun, I'm now retired, I'm both veterans. We know how to use.
so in that fact pattern, you've got retirees, which are traditionally more vulnerable, and that's what the criminals like to prey on, is the young, the old, and the people that have problems, right? So it would fall within our scrutinizing it and making sure that we don't unnecessarily charge people that shouldn't be charged.
So, last question, I'm just trying to clarify the law. Once they're in your home versus leaving the home after you warn them, you pull out your gun. I keep hearing this thing, shot in the front, shot in the back, and leaving the home, you warn them, so you're no longer a threat. So,
No.
some people, I can see them just firing because they're just as young, but they're leaving.
You raised an excellent question. Did you know that this statute also allows for kidnappings to go after the person? Just say that they grab your daughter and are running out of the house and are already in their car going down the street. That thing seems to say you can chase them down. So it's not necessarily a bad thing, but the hot pursuit, this idea that, so you're talking about the person's in the house and then does what they're doing and they're on their way out trying to run and you shoot them on the way out. Well, the argument would have to be made by the homeowner that he was gonna come back in and get the rest of it. So, you know, we would bend over backwards to try to look at the like most favorable. But remember, guys, this is not a license to execute. That's the danger. The vigilante justice, you came to my house, how dare you violate the sanctity of my home, I'm going to take you out. That's what we don't like to see at the AG's office, but at the same time, that has a good basis. Anyone that walks in your home, they're subject to getting shot. That's what the people out there, the criminals have to know. If you go to somebody's home, get ready, you know, and don't do it. So, thank you. Good questions. Those are the shades of gray and nuance that when you're doing a police report, make sure you say the right things. You know?
Video camera footage. I have video cameras all around my house. And let's say something like that happens. So I was assuming that the almost department did that video and have a key matter.
Again, it gives a presumption of using deadly force when you have the proper notices up and they're in that area. Okay? So the law says that you have a right to use deadly force, assuming that you're afraid. You've got the cameras, that's just the proof part of it. Whether you say that you saw them, that's proof, or your videos say that, show that they were there. So that's what the Castle Doctrine protects.
He's got one question for this next.
I've got a service here. Let's compare, I unfortunately shoot a man in my house who attacked me with a deadly weapon. I was not innocent in self-defense. During the course of the things. My question is the following. The man that got shot, who assaulted me, survived. And he's crippled. Am I financially responsible for him?
Good question. That's the civil side of the statute. When the senators passed this law, it's criminal protection and civil. So you have a right to be protected against a lawsuit by the guy that was victimizing you. So it's a good thing. Plus, you got to pay the person, the plaintiff that sued you has to pay your attorney's fees. So it's good law.
So I have young children, and I'm more concerned about, our vulnerable, putting them in the car seat, climbing outside my car, putting them inside the car seat. Would that still be covered under the Castle Doctrine as it pertains to privilege and so? I heard the department answer about inside the car with the privilege, but if I'm putting my kids inside the car seat and securing them, or exiting my vehicle, I have to get assaulted or something as I'm stepping out of my vehicle.
Good question. In that fact pattern, we probably just revert to self-defense, and you have a right to, the duty to retreat is part of that self-defense. The rule is that when a person's coming at you with non-deadly force, you have a duty to retreat if you're in the public. In your case, you're right next to the car, so you have that kind of car protection, and from an AG's point of view, you're still within that protected bubble. You have a right to not have to fear, because that is your property. You're trying to be safe in the car, especially with the kids. You put the kids in any of these equations, and I'll bend over backwards. With the chief of police, the police officers, I bend over backwards with those guys. Because, guys, this is not a perfect world. When you're out there, you've got all your hormones flowing, you've got your blood rushing, you've got the fight or flight going on in people. In our office, we try to be as reasonable as possible given the facts. We look for meth, we look for prior criminal convictions, we look for propensity for violence in individuals, we look for family connections, if there was another motivation for this. That's all part of the investigation that goes on by law enforcement.
Yeah, sir, I appreciate the clarification because I've been through several times with my kids in the car seat, and it's usually someone looking for a handout, and I say step back, step back. But you never know, at night, especially I can't see them before you
Right.
Thank you for the
In a fact pattern like that, when they're approaching you, step back, and then if they're still continuing, just pull the gun out. And just say, keep doing it, But that's why I say, guys, there's a lot of ways, depending on who you door to approach a situation, shooting the individual should always be the last step. Aaron?
Yes, we had a question back here. The question was, my door was not open, the guy just walked in with the Castle Doctrine applied. And as I read it, yes, it's not of course. I don't know if that was addressed earlier.
Interestingly, we were discussing that this morning. There is a provision in Castle Doctrine. If your door was open, the first part of the Castle Doctrine says that it has to be by force for the unlawful entry. But then, unlawful entry. But then there's a section right after that that says that if you walk into somebody's house and the door was wide open, Castle Doctrine still applies. You're there unlawfully.
And our control council, I think is that question.
I feel like there needs to be clarification on, with regard to privilege and people just coming onto your property. So if I walk into somebody's property, I feel like in the whole course of the discussion, I feel like the message was, someone has a right to shoot me. And I think that that's not the intent of anything.
See, this is why I never supported that the privilege part of it. I was understanding what it is. Weren't you?
Before you answer, can I add to her question? If there's anybody in this room that is guilty of trespassing, I promise you, it is me. I have been trespassing since I was a teenager with my Benjamin.
How's the shirt?
Right? And nowadays, I'm getting nervous because what I'm hearing and hoping that we're wrong is that shooting someone is justified for mere trespassing. And something tells me that's not right. Shouldn't self-defense be, even with the Castle Doctrine, is it real? Do I misunderstand that the intent is not to protect the castle, but the occupants of the castle?
I think it's important to keep in mind here, I mean, that's an important question. Of course, we don't want to imply or give the impression that it's just okay to shoot someone if they're unlawfully on their property. Remember, the key component of this is that you have to have a reasonable fear of imminent peril of death or serious bodily injury, either to yourself or to others. So without that component here, the Castle Doctrine won't protect you. So if you just see someone come on your property and they're unarmed and they don't appear to be a threat for not making verbal threats towards you, if you haven't had encounters with them in the past, and don't have reason to fear them, then you wouldn't be protected by the Castle Doctrine. So I want to make sure that we're absolutely clear in that. Just because someone is trespassing on your property, that does not give you the right to use deadly force. You have to have imminent peril of death or serious bodily injury to either yourself or to others on your property. And again, that's based, you got to factor in, you got to take into consideration all the various factors that are involved. Does that make sense? Okay. I know there are a lot of other questions here. Oh, okay. Yes.
I just want to bring clarification because there are people here to see, and again, during the course of this seminar, feel that if somebody comes onto my property, not just walking, but even if I wanted to steal something, some people here are walking around thinking that you could shoot me.
Oh, no, absolutely not.
And we need to clarify that.
Yeah, the statute is open.
Yeah, we have to be careful because that is the law presumes that you can use deadly force for the person in your privilege. That's how the statute is structured. So,
but you still have to have that component.
A person is presumed, you can pull it up under 7112.
But they have to have that in that.
A person is presumed to have held a reasonable fear of imminent peril of death or serious bodily injury. Now, the rebuttable presumption that Grant is mentioning, if we find that you put the execution, this idea of execution, if the AG's office decided that although you have an initial presumption that the person was there to commit deadly force, if the facts show otherwise, you can be charged. So that's why it's not able to
understand.
Yes, they have to understand that. Yeah, that's why the example by Mr. Cruz over there was very good, because it brought it out that, you know, this farming idea, the person wasn't really there doing anything, take a step out of the farm.
My name is William GTK, and I recently came back home. Just got out of the Marine Corps, and let me explain something to everyone. I get very pissed off about a lot of things since I came back. And the main thing here on this island is that I've seen is there's no respect. Respect has gone out the window. The least you can do is just go up and say, excuse me, I'm just passing through, I'm lost. You know, be respectful. Don't just make yourself home, come over and do the property, still, you know, ask. Ask goes a long way. Get permission. Don't just come and just take. You know, that's and I eat it. But when things are going out, you gotta make your own, farm, like your own business. As they're going up, right? It's killing us. What we do, I come home, and then I get present. Going around, I finally just reasoning up and zero. I'm getting sick of this crap. You know, sorry, because I get very emotional. I just talk about a lot of things. And one thing too, very good where I was also a great one. Never point a weapon at anything you do not intend to shoot. That goes a long way as far as self-defense. Yes, they're going to cause bodily harm to me. I will warn them. First thing, disarm them. You know, we're shooting their hand. Because you can't shoot them, you don't have a hand. You know what I'm saying? Stuff like that. But this, I was told because I said, excuse me, you're on private property. You're stealing. What are you doing? Well, I was told, who told me? Because you're not looking at something, somebody told you who.
Right, and that's why the curtilage is so dangerous, because you have that opportunity, you're outside of your structure, to talk to them, to try to de-escalate the situation. There's a lot, that goes to the reasonableness, the practical side of life, versus 2 o'clock in the morning, you see that shadow in your house, that's where it's more likely you can justify it.
Okay, so a lot of these students are coming home. God darn, this drug thing, this shit's gotta stop. So disgusted here, you know. Ever since they, made marijuana recreational. Marijuana shouldn't be recreational, because the smoke of it, recreational. They're getting high along the road, killing people. They're not killing themselves, and killing others. You know, all for drugs, and they say, oh, it's drug related. Oh, you're gonna do drugs, and you kill a drug person? That's your down business. Right? Don't come to my area and threaten me. You know, because my mom's house got robbed. Sure, Mr. William King. William King.
Yeah? King up, Mr. King. Thank you.
So, you know, I mean, it's like,
you said it what I said at the schools and stuff, respect. If everybody steps away from whether you can shoot somebody or cannot shoot somebody, you treat everybody on the lawn with respect. We're an island, we're a community. We don't like shooting people. And by the way, I think everybody in this room knows all those guys that came back from Iran or Utah, Vietnam, people change when you kill somebody. It's not human nature to kill people. So you're really changing yourself if you choose to shoot somebody and kill them. Thank you, Mr. Speaker.
I'm dealing with it with my neighbors. Their son, he stole from his mother. Just to make money to support his drug habit. You know, he didn't force him. He said, no, we come over here. We bring people passing through here. So now, I'm going to put up a fence. Put up no trespassing. You know, you put up the fence. Now, what business is it then to open up my fence? Well, you know, I can put my number and say, contact me, you need to pass it. Instead of just passing through. You know, respect. Respect. Before growing up, we used to leave our doors open. Now
Thank you, Mr. King.
My mom was alive, and I didn't make it clear. I said, God forbid, if my mom was home, and somebody were to come in and do any kind of harm, you know, I'm sorry to say, but, you know, I'm not trying to look for vengeance, but I never point a weapon at anything I was not intended to shoot. I wouldn't point it, so if I had to, I would disarm him. That's the first thing. You don't just shoot to kill. You shoot to disarm, like you said. Shoot him on the leg, shoot him on the hand. If you're gonna shoot somebody, the only time I would do that is where you're pointing the gun at me. And I've had guns pointed at me, and I told them, the biggest mistake was pointing that gun at me. Because I never pointed guns. And I didn't want something done. In other words, I wouldn't do something to someone I wouldn't want done to me. So when they do it to me, it's very, you know, disturbing to me. You know, it's like, I always see, but you know, being concealed carry is for my protection. And that is not when that time comes. But I would use it if I were to go to a shopping mall and I saw somebody, you know, doing harm to everyone else. That's not at all. Right. But what you can't do nothing if you don't have nothing to protect or to help out. You know, that's all it is. And you got to put that person out. This drug thing inside is just crazy. And probably were listening. I'm glad I hope. I wish I could tell the world excited. Ever since they did that recreational thing, I had a great son killed. I went up to Vince Grail, that boy that they killed. They tied him to a chair. 3 of them, hit him in the back until he died. And the mother asked me, what do I do? Because I was served with his husband. And I said, you prosecute. Well, they're just family. And it's just family who killed that boy. I babysat that boy. He didn't do nothing wrong. Sure. Okay, so he did marijuana. Everybody else is doing it because it's recreation.
Right. Thank you, Mr. Kingo. And thank you for your service. You said you were a Marine, right? It's always the Marines that seem to lay the law down.
What is the duty to render Army?
Oh, Army, I'm sorry.
What is the duty to render aid? Let's say you shoot somebody in the house. You have a duty to put a furniture on. You're told you see the render aid.
Not that I'm aware of, but it just goes out in the I don't know of any duty to render aid. But if you shot the person improperly, because my wife is alive.
Attorney General, I have a question for all of you. It's so vague. What is a threat? When somebody comes at you, I always thought was within arm's reach. They're coming right at you. You can touch them. Is that a space, in space where it's, you know, a threat? In other words, instead of 21 foot. I always use it in entertaining terms that within arm's reach. If I had someone get my face,
They like to use the word reasonable, objective, third-party standard. So your idea of what a threat is should be similar to what someone else's idea of a threat is. And what is not a threat is also, there is, like we go to law school, first year of law school, they usually tell you the reasonable third-party standard. It's such an amorphous animal because your idea, that's why the juries are there. You have to just listen to what is a reasonable threat. So,
the reason why I came here was my siblings told me, what they said, you need to go and better understand things, you know, to protect yourself. So like property, like grandpa's property, family property, they're little hills, like driving ranges, I had outsiders going. They're holding the gun out, I had a gun all night and a chain gun. Now they do that school where the dogs are and it says holding the shotgun. He said, you take that for there's something wrong with this picture. I have right here in this property, and you're threatening me. You gave that authority. You know?
right. A lot of fact-specific stuff, sir. We're just giving the framework right now, and you know, we're hoping that that's why, like you said, respect, life is precious. Try not to kill somebody if you can avoid that. You know?
I usually have friends doing the force. They always give me the body support. I say, they're going to check something. So right now, I'm making that clean up those signs, you know, no hunting, no trespassing, private property,
it's outside. So you want respect for their doors.
Thank you, Mr. Gator.
Two quick questions. One question was, you want to think about the no trespassing sign, but what about, is there a sign there? Say again?
It just has to be curtilage. So no trespassing, it says here, property is enclosed or reasonable notice is placed on the boundaries of the curtilage if the property or residence is a no trespassing zone.
This curtilage doesn't apply to this.
Yeah, because clearly if it's a business or a dwelling residence, then unless you have permission to be there, you can't be there. So, yeah, so the notice for no trespassing applies to the curtilage, the boundary of the curtilage.
And the second question is regarding the use of deadly force. What if that's done by an animal?
Are we protected if my dog?
I think that could be considered, if your dog isn't certified like Ed told us when he trains my dog, if that was a trained guard dog or whatever, the government
It
mentioned.
has to be trained. I mean,
No,
he's in a,
if you know your dog is gonna potentially kill or hurt somebody, and you let him go after them,
Dog on someone,
my dog's name.
yeah, I don't think it
And I
can change
have to say, my dog, you know.
Yeah. As long as you have the other elements establishing that
Castle Doctrine.
right, that apply.
That's the curtilage, but those notices are very important for the curtilage.
Yeah.
On my personal property, I have a dog on premises, it's my sign.
Yeah, but this one says no trespassing, so you have to have a no trespassing. But I kid you not, put up some sign that says, what is it, trespassers will be shot.
Okay.
That'll make it very clear, so you don't have to worry about
Is
it.
private property sign the same as
Steve, real quick, we're gonna wrap
Yeah,
this up.
can I just mention something real quick, because I know the main topic is common sense, right? So I know basically, most of us here have taken a basic district course or concealed class, right? So I know for the use of deadly force for the police is AOJ, right? Does a person have the ability, the opportunity, jeopardy, your life in jeopardy, right? For citizens in there, for just us civilians, right? It's AOJP, preclusion. So I guess preclusion defines common sense. Because some people are confused on when do I shoot?
Yeah, but you know, every fact pattern, every jury, that's why we have you're automatically guilty. The jury has to listen to everything. And then you got that whole factor, the jury may hear everything, may be dead to rights, the jury ain't gonna convict you. Like of the firearms and not having the power of the ID. So, okay, well, thank you, let's wrap this up, ladies and gentlemen. And again, I want to thank Mayor Paco, Joe Ariola, and all of you for being here.
Just for everyone, we do have some rules here, they can see that, and we're recruiting, right?